Hello everybody, my name is Anju, Balakrishnan. I'm a legal intern of LEXIS and Company, and today I'm going to talk about the elements of the contract of guarantee. So, the contract of guarantee is governed by the Indian Contract Act and is considered to be a contract made in cases where a guarantor provides the guarantee to do the duties that the defaulting party fails to do when it died. Basically, it consists of three parties, and such events is surety or the guarantor guarantees the creditor that the person in need can be trusted, and in event of default, he will accept responsibility and fulfill the duties of the principal debtor. There are three parties, as I mentioned, and the three parties would be the principal debtor, the creditor, as well as the guarantor. The principal debtor is the one who borrows the money and or is who is obligated to pay, and to whom a guarantee is issued in the event of failure. The creditor is the one who supplied something of value in exchange for a loan and stands to receive the payment for it, as well as the person to whom the guarantee is delivered. The guarantor or the surety is the individual who guarantees to pay in the event when the principal debtor is unable to pay or complete his duties, basically when during the default of the principal debtor. These are the three parties involved during the contract of guarantor. There are some elements essential during the contract of guarantor, during the when these elements have to be fulfilled when the contract of guarantee is made. The first element is that all three parties must agree to create such a contract with each other. That basically means there should be the consent of all three parties, and it's critical that the surety or the guarantor accepts the responsibility of the principal debtor on the request of the debtor. He cannot go on his own consent, on his own wish or no, or his own consideration to say that I want to do his duties, I want to fulfill his duties. No, the principal debtor has to request the guarantor to complete his duties on his behalf. So basically, it is important that the principal debtor communicates with the guarantor either explicitly or implicitly. There should be communication between the three about such a contract, and primarily or basically there should be communication between the principal debtor and the guarantor. The next one is that anything done or promised for the primary debtor's advantage is considered adequate consideration for the surety to provide the guarantee. So basically, anything done for the advantage of the primary debtor would be considered as a consideration for the surety. And the consideration must be a new consideration and cannot be the older consideration made with the creditor. It should be a new one on the basis of the new contract made. It is not required for the guarantor to be compensated in any way. The compensation that the guarantor can require is from the creditor is that he gives him more time to pay back the money. Other than that, it's not important or it's not compulsory that he requires or he gets a consideration for paying on behalf of the default or on behalf of the primary debtor. The next element is that the surety's liability is considered to be secondary because the main agreement or the main contract, the original contract happens between the creditor and the principal debtor. It is when the principal debtor is unable to fulfill his duties that the surety steps in. So basically, the first contract happens between the principal debtor as well as the creditor, and hence the main liability happens between these two. The liability of the guarantor is considered to be the secondary liability, which occurs only when the primary debtor is unable to fulfill his responsibilities. The next element is that the fundamental purpose. Basically, the fundamental purpose of contract of guarantee is the payment of the primary debtors or the principal debtors obligation. And if there is nothing left to pay, then there would be no such contract, there would be no such debt. Basically, if there's no debt, then there would be no need for a surety in order to secure the debt. So in instances where the debt is time barred or invalid, then the surety has no obligation. So basically, the fundamental or the basis of a contract of guarantee is the payment or the obligation of the principal debtors. And if there is no obligation at all, then there would be no reason for the surety's obligations. The next element is that because the contract of guarantee is a form of contract, the essential elements of the contract has to be applied while such a contract of guarantee is made, such as there should be agreement, there should be consideration, there should be capacity to contract, there should be compensation in cases of breach of contract. Basically, all the elements essential for the contract should be present during the establishment of the contract of guarantee. The next element is that the creditor must inform the surety of any information that may alter his responsibility. If the guarantor as providing his acceptance in order to be a guarantor, after an information is concealed from him, then such a contract would be considered null and void. Basically, the creditor must inform the guarantor of all of his responsibilities completely. The next one is that next element, or the final element, is the same as the previous element. Basically means that the guarantee should not be acquired by lying to the surety about the facts. The contract of guarantee is not considered to be a contract of absolute good faith. So it's not required that all the significant informations must be disclosed, or the creditor and the principal debtor provides all the information. However, the facts that is associated with the guarantees and the responsibility of the guarantees or the liabilities of the guarantees must be completely disclosed to him. It is not important that all the elements of the contract is established. What all are related to him must be disclosed to the particular person. These are the elements that are essential for the contract of guarantee, and without the fulfillment of these elements, such a contract would be considered null or void, and such a guarantor, such a responsibilities of the surety would be considered void. So hence it's important that these elements are fulfilled. I hope that you could understand what a contract of guarantee is and what are the elements required for such a contract. If you like the video, please press the like and subscribe button. Thank you for visiting our channel. Please continue visiting our channel in order to get more law related videos in the upcoming days. Once again, I thank you for your time and understanding. I hope that you have a wonderful day ahead.